If you please rise with me for a moment of silence in the invocation and then pledge allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, for roll call, we have Council Member Camp online tonight, and Alma is out sick. She called me earlier today, so if I could have a motion to excuse her tonight.
I'll make the motion to excuse Alma, or Councilwoman Carmona.
Second.
Okay, all in favor?
Aye.
Aye.
Opposed? Okay, so carries. Now I need a motion to approve the agenda.
I make that motion to
Mr.
approve
Mayor.
tonight's agenda.
Public input?
Oh, yes, can't forget that. Have we got anybody that would like public input tonight? Please step up to the podium and state your name for the record, please.
Good evening, I'm Jake Mendez Jr. I'm a civil rights activist, an ACLU Washington member, and an NAACP member as well. I just want to come here tonight to thank the Othello Police Department and the Adams County Sheriffs for dealing with the shooting incident that happened near Pick-a-Pop involving teenagers. Now, I come here to acknowledge this situation and to the city council that we need to be more aware of what's going on in the community of Othello. We need to not just ignore and just continue business as usual as if this didn't happen. It did happen. My suggestion is that we, the city council, and the people, we should talk about this. And this is not a point where this is your fault. That's not where I'm going. But we need to ensure the safety of our community throughout the daytime and nighttime when it comes to these incidents. Any stray bullet could have went through any home and hit a child, an adult, anyone. Could have been anyone's family here tonight on the board and the people behind me. We need to talk about this and address this to ensure the safety of the community. That's what you guys campaigned on. That's what you guys wanted to promote on your campaign for change and safety. And here we are. You guys are at these seats. You guys are elected. The question is, what are you guys going to do about it as a city council to ensure the safety for the community in general? We need to acknowledge this situations where we need to address it. These are human beings. These are constituents of children that could have been impacted that voted for you. But yet we're here. You guys want to go on the agenda that's a pretty short list. But it would be grateful if the council and mayor could at least acknowledge the situation that's happening. We need to not ignore what's happening, but we need to address what's happening so the community can get involved so that we could all ensure the safety of others. That's all I have to say. Thank you.
Thank you, Jake. Okay. Now we'll go on to approval of the agenda.
I make that motion to approve tonight's agenda.
Second.
First and second. Any discussion? All in favor?
Aye.
Aye.
Any opposed? So carries. Now we'll go on to the consent agenda. Do I have a motion for that?
Mr. Mayor, I make a motion to approve tonight's consent agenda.
Second.
We got a first and second. Any further discussion? All in favor?
Aye.
Any opposed? So carries. That takes us right into current business on the open government training. And I believe we have Joanna with us
Hello.
tonight.
Yes, I am here. Are you all able to hear me all right?
Yes.
Excellent. Okay. I like to check that before I start sharing my screen. So this is going to be a training, just kind of an overview of open government. And so mostly on the Public Records Act and the Open Public Meetings Act. There's some other materials that are available at the end of this presentation that I wanted to include there, but of course I'm not going to get to because this is a very lengthy presentation. But it will be a little fast and furious because I'm going to compress it down to 30 minutes. But it does have some good reference material for you to be able to refer back on. So with that, I'm going to go ahead and share my screen and jump into the presentation. All right. And hopefully you can all see that all right. Let me know if there's any trouble. Okay, so again, I'm Joanna Eide. I'm from Kenyon Decent. Kenyon Decent provides city attorney services for the city of Othello. Some of this is going to be a refresher for many of you if you've already recently attended the new elected official training or have recently read through the mayor council handbook. So I wanted to start off just with a quick overview of how city government is divided up and functions. There's, of course, a ton of wonderful resources that are available to you in addition to this online, both from the Association of Washington Cities or the Municipal Services and Research Center, Research Services Center. And I do recommend you take a look at those resources regularly because they have a lot of wonderful things available to you. So first, I focused on the mayor council organization here for the city of Othello, given that we do have a mayor council organization. The policy and administration is separate, and the council performs the legislative branch functions of government and is vested with all the policy-making decisions and legislative decisions for the city, and also, probably most importantly, the budget. They exercise that power through ordinances and resolutions. And the mayor serves as the city's chief executive, handling the day-to-day operations of the city, and also bringing policy recommendations and even a budget proposal to the council, but ultimately it's council who makes the decision on the budget for the city. The mayor's also, as the chief executive officer for the city, responsible for the supervision day-to-day operations regarding staff and personnel. And generally, I just wanted to just quickly mention that, authority can only be transferred if it's expressly given. So for instance, only city councils have the authority to contract. However, it's pretty common for cities to delegate some of that authority to department heads, such as like the city manager or the mayor in this instance. Technically, each time the council approves a contract and directs the mayor to sign it, that is an individual delegation of contracting authority for that specific contract. So sometimes we can handle these things on a larger basis through our procurement policies, and sometimes it can be on an individual basis. So talking a little bit about council member representation of the council as a whole and individually, I think the most important thing to remember is that be very clear on who you are speaking on behalf of. As a general rule, I recommend that you're only speaking for yourself unless you are 99.9% certain that the statement attributed to the council as a whole is accurate and is a accurate representation of the council's position. So it is really important to say, okay, I'm council member so-and-so, And these opinions and any of the statements I make tonight are my own and not necessarily representative of the council as a whole, but make that distinction. And then also, if you do want to be able to speak on behalf of another council member or the majority of the council, you do need to obtain that actual permission, the authorization from them to be able to do that prior to engaging in that activity. Council member responsibilities are a few very large things that are very important to the proper functioning and of the city in general. But in order to do that, you have to show up. So attendance is important, either in person or virtually. Preparation, making sure that you're informed, participating in a manner of decorum, so that everybody has an opportunity to be heard. First Amendment is a very important thing for council members all to abide by and respect. But that only goes so far as we can allow others to be heard as well. So making sure that we're following our proper procedures. We need to refrain from interruption, and then also following Robert's rules and council rules is also a very important way to be able to make all of that happen. And there's a good reason for that. You know, all taking turns to speak allows for everyone to be heard. And, you know, when we share that collective discussion about things, it can help better the decision-making process overall. I do want to mention that you know, there is an obligation to follow Robert's rules in general, even absent council rules. So even though they're not like legal requirements, it is a widely accepted practice, of course, to be able to adhere to those rules. You don't necessarily have to be a parliamentarian or an expert, but you know, generally following the principle and spirit of the Robert's rules is very important. I will also mention on attendance, there is state law, RCW 35A 12060, that does state that council members' positions shall become vacant if the council member fails to attend 3 consecutive regular meetings of the council without being excused by the council. So I was glad to hear the motion to excuse that council member that requested that excused absence for being ill today. Those are perfectly appropriate ways to do that. There, of course, these are not necessarily, you know, hard and fast. We can also find out more information at a later date. So, you know, certainly reach out to us if you have any questions about those things. So quickly on public records, and this is probably one of the most important things to remember as a public servant. The Public Records Act applies to you all just as it does to any other government staff member and government employee. And why should you care? Well, it's a strongly worded mandate for broad disclosure of public records. It's largely in Chapter 4256 RCW. And along with the Open Public Meetings Act, it was established through the passage of the Citizens Initiative in the 70s. They actually followed each other one year after another. So we just celebrated, I think, 50 years of one being in effect, and then I believe we'll celebrate the other being in effect for 50 years this year. It does require open government, full transparency, and full access to information by the public. What is a public record? Well, that is very broad. Public record includes any writing containing information relating to the conduct of government or the performance of any governmental proprietary function prepared, owned, used, or retained by any state or local agency, regardless of its physical form or characteristics. I think that's really important. Obviously, writing is also defined. You'll see that here in the bottom of this slide. It's really small, so sorry about that. But if you need to check it out in its entirety, feel free to Google or use your favorite search engine to look up that RCW there, and you'll be able to read it in its entirety. But I think the most important thing to remember is that it's incredibly broad and basically can encompass anything, whether it's a picture, a recording, microfilm, you know, it runs the gamut. So, and there's also a difference between a request for information versus a request for records. So a request for information is kind of a general question. Basically, a good example of that would be how many permits were issued in 2025. And that's not a public records request because the city doesn't have to create records or do research in order to answer that question. You don't have to necessarily supply a document for that. But if it is instead the disclosure request that asks for specific existing documents, such as give me copies of all the permit applications from the last month, that does create the obligation underneath the Public Records Act and to follow the procedures under Chapter 4256 RCW. So request for information is a general question seeking data or answers and not necessarily a specific document. But a public records request in contrast is something that is specific and identifiable. So that's pretty critical as well. So they have to state it with enough specificity for it to be identifiable. Usually that's pretty easy to do for the most part when you are receiving public records requests, but sometimes it can be a little murky. So always err on the side of caution and be sure to check in with your public records officer, or you can check in with, of course, our office, and we would be more than happy to help you determine that. There's also a difference between production and disclosure. So what the heck does that mean? Well, it means that the agency still has to search for and gather records, regardless of whether they are actually required to be produced or not. Records can only be redacted or withheld due to a specific statutory exemption, and even then must be accompanied by a citation to that authority exempting that record or portion of it. It's usually called an exemption log. And there's a little example of that here for you. So if there's a redaction or if something is exempt in its entirety, we would cite to what is the specific exemption underneath the Public Records Act that requires that. But this is what it is meant by disclosure being made. You're still disclosing the existence of a responsive record, but you are not producing it due to the statutory exemption you are citing to. Searches are an incredibly important part of the Public Records Act, and the sufficiency and adequacy of searches regularly comes up in public records litigation and case law. But essentially the obligation is that the agency must conduct an adequate search for responsive records, considering all formats it may be in, whether paper, electronic, or otherwise. Records of current staff or officials, former staff or officials, and even those that the city has contracted with. So if it's a consultant or some other entity that's operating as an agent of the city, may have potentially responsive records. And also you have to consider the possible locations where things are reasonably calculated to be located. So you don't necessarily have to search every single portion of your computer, right? If you believe that you may have a document in a particular file, but you do need to search where that record may reasonably be located in order to find that responsive document. And an inadequate search is actually comparable to a denial. Where cities get in trouble more often than not is failing to produce or disclose a record that should have been disclosed. And that can happen for a variety of reasons based upon like an inadequate search or, just missing it or something. And each public record request is, of course, unique and is going to require consideration of different formats and locations for those records. It's also a really good idea to document your search efforts in some way, shape, or form. Sometimes cities will adopt a form that will assist people in documenting their searches. It also helps people remember where they should be checking, which is also very useful. And then also a request can require a search by numerous staff members. Cities' IT staff, of course, too, may be necessary to search for some electronic records as well. So assistance with searches is required, and this means that for all public servants, public records are everyone's responsibility. It is important that you do your part to gather records for requests you're asked to produce records for. Even if there's only a small possibility that you may have a record, it's good to search anyway, just to be careful. Sufficiency of that search again, and good faith efforts are extremely important, as case law has stated. Obviously, everybody makes mistakes, right? So we can't be perfect 100% of the time. But I think what's most important is to try to reasonably calculate, without being overly onerous, trying to locate those records and do the best you can, and in good faith to find those records. And then also don't be afraid to speak up. If you have made a mistake or overlooked something or found something later on, the longer you wait, the worse the outcome can be. And the quicker we can actually locate those things and usually be able to supply those things to the requester without there being any adverse impact to the city. Because again, we are all human. Everybody can make mistakes, but it's just really important about what do we do with that once we know about it. Obviously, I have a citation here from a particular case, and I think it's pretty obvious when you read through this that the city, in this particular instance, did not have an adequate search. There was a lot of holes in this, so these are things not put here to scare you, but so that we can learn from them, and apply things in a positive way moving forward. Exemptions, as I said earlier, the Public Records Act is very, very broad, and it errs on the side of disclosure. Records are presumed open, and if a record or part of a record is withheld from the public, again, we have to cite to that exemption in law and give a brief explanation for that. Those exemptions must be as narrowly construed as possible. So, withholding a public record or a portion of that information that's part of the public record, it has to be authorized by statute. That can be in state law or it could be in federal law. There are some requirements, especially associated with driver's license information and things of that nature, that are federal requirements. There's a number of exemptions that are available. If you're ever curious about learning about how many there are, the legislature maintains a list of that. It's actually kind of interesting to look through it. Agencies can't withhold records based solely upon the identity of the requester or based upon discomfort or embarrassment of what the record contains. The general rule is that the agency can withhold only the exempt information and we release the rest. And that means even if a very small portion of that record can be released unredacted, then it should be. So sometimes those records are going to be confidential and release will be fully prohibited, as is the case with like certain healthcare records, records related to juveniles, or some criminal records. But largely, again, those penalties that cities will see, they come about when a record's withheld or not produced when it should have been, and not for disclosing too much. As I like to say, when in doubt, give it out. Of course, there's a couple very small exceptions to that, where there are penalties associated for giving out information. But generally, those things are going to be things that you will expect that would be an issue to give out. There is kind of a misunderstanding, though, about privacy and whether there is a general privacy exemption in the Public Records Act. And there is not, actually. So when we're just considering disclosure of a record, we need to remember that if privacy is expressed as an element of a specific exemption, privacy is considered to be violated only if disclosure about that person would be highly offensive to the reasonable person and not of legitimate concern to the public. More often than not, it will not be falling underneath this general privacy redaction or exemption from disclosure. Because more often than not, it is going to be of legitimate concern to the public. Again, there's going to be some exceptions for things that are quite sensitive. But again, those are things that we would be working closely with the city on identifying and ensuring are handled appropriately. So some common exemptions, just to kind of run through those for you. Personal information regarding like credit card information, social security numbers, things of that nature, attorney-client privilege information. But that exemption is not as broad as you might think. Simply carbon copying an attorney on a message does not necessarily make that message attorney-client privileged. It's not as expansive as just doing, oh, I copied the attorney, so therefore it's privileged. It actually only protects confidential communications between a lawyer and client for legal advice, preventing disclosure of that underneath the Public Records Act if the communication is intended to be private and for legal counsel purposes. Obviously, there's some exceptions to that too. There's always exceptions to everything, you know, like us lawyers have to, you know, yes, keep ourselves in a job. So also applications for public employment, including names, resumes, and other related information, those are exempt from disclosure. Test questions, some records relevant to a controversy, and then also open investigative records. I want to be careful with this one though, because the open active investigation exemption is also not as broad as you may initially think it is. Once the case is no longer being actively investigated or is referred to a prosecutor, even if some additional work may be needed on the case thereafter, it is likely not exempt as an open investigation. There may be components of it that might be. It really is a case-by-case basis, but more often than not, it will not be considered an open investigation. I think there's a couple others that I do want to mention. I touch on. I want to make sure I do. So there's a draft exemption. So some drafts don't have to be disclosed while they're in process. Again, that's not as expansive as you might think. Don't bet on using this as like a shield to keep a draft from being released. Like usually more often than not, it's better to just release it. Or if it is something that you want to make sure is in a solid state, you know, once it is completed, that draft exemption isn't going to apply anymore. And if you have it in your possession, it's going to be responsive. Also, notes are disclosable if you have them. So long as they're in your possession, they may be subject to public records requests. If they're transitory records, however, you might be able to handle them underneath the standard, records retention schedule for destruction once they're no longer needed. So a quick note to yourself that doesn't necessarily have any like policy decision making or things like that. Those are probably going to be transitory. They don't necessarily need to be kept forever. You can likely get rid of them once they are no longer needed. I don't want you all thinking you have to like save every post-it note or something that you put on something to remember. I know I have to write everything down in order to remember anything. And I will say, having also myself been a public servant for a very long time and been subject to the Public Records Act, I survived and you too will survive. And it's not as onerous as it sounds. But of course, when we're training, we have to talk about the risks in order to avoid them. So pop quiz. Who knows how Public Records Act penalties are calculated? No one really has to answer this because the answer's on the next slide. It's per day per page. So RCW 4256-550 subsection 4 states that it is an amount not to exceed $100 for each day that the person was denied the right to inspect or copy that public record. So that adds up really quick, as you can imagine. And this is for individual records, not necessarily pages, but still, court could basically put $100 on every document for every day that it is not handed over to a requester. There are some mitigating penalty factors that can apply. There's also some aggravating penalty factors that might apply too, which I'll get to on my next slide. But so factors that can reduce the penalty, I'll list them here for you. It's pretty much, as if we're operating in good faith and we are trying to fix a mistake, then we're likely not going to be penalized for something like that. If the agency is in good faith, training its employees, trying to do the best it can with the resources that it has, then it's likely going to be a mitigating penalty factor. And of course, the reasonableness of any explanation for that oversight as well. So for the aggravating penalty factors, these are factors that can increase a penalty. Delayed response by the agency, especially when, circumstances apply that time is of the essence, lack of strict compliance with procedural requirements, and lack of proper training. Just unreasonableness of the explanation as to why the records were not provided, especially if it's like a very simple request. The court's not going to look very kindly on that if it's not turned over. And things that are negligent, reckless, bad faith, or intentional noncompliance. There's also issues with destruction of public records. And if somebody is like willfully destroying public records, that is a serious, serious offense, and actually is a crime. Which I will touch on as well. But OPMA, I know we're going fast and furious, and this is a lot of information. I'm so sorry. So quickly on OPMA, this is the Open Public Meetings Act. And this is going to be a quick refresher for you. So I think understanding what a meeting is probably the most important component of the Open Public Meetings Act. A meeting requires a quorum of the council gathering with the collective intent to engage in agency business. So how agency business is defined is very broad, but I think remembering those three things in general are the most important factors for considering whether or not you may be in a situation where the OPMA may be violated. So is there a quorum of council members present here? Are we gathering with the collective intent to discuss city business? So that's not going to cover you if you're like all of a sudden you have a quorum of council members at the grocery store, right? That's not going to be considered a meeting unless you guys get together and start talking about city business, right? In which case, don't do that. That is going to be a problem underneath the OPMA. So really the whole point of the OPMA is making sure that the public has a reasonable advance notice and opportunity to attend and be able to be involved or hear the overall agency business. They want those things to be open from gavel to gavel. Deliberations need to be conducted openly, and what is considered an action is incredibly broad, even just a minor discussion or deliberation. There's a whole list of things. So just think about it as we're talking about city business is probably getting into danger zone, right? And again, this doesn't matter whether you're actually physically present with each other or not. You can also have this occur through email or other electronic means. So I'll cover that point on the next two slides here. So again, it doesn't have to be titled a meeting in order for it to count as a meeting. It does apply to retreats, workshops, study sessions. Again, that physical presence is not required. No meeting occurs if the governing body lacks a quorum. So if it's only 3 members of the council, it's probably fine for them to sit around and they can talk shop all day long because they don't have the ability to make any decisions, right? That would be binding on the city. That is really the kicker. So that's why the quorum is so important when it comes to the OPMA. A minority of, a number of members on the council doesn't have the ability to make decisions on the part of the city. So there's less concern about that. But there are ways that they can become a concern. So beware of serial meetings. So these are kind of like your telephone game or phone tree, right? Where you're trying to avoid, getting crosswise with the OPMA by calling up a bunch of people and, kind of having this rolling meeting situation. Please don't do that. If a majority of members are eventually all involved in that exchange, it's going to be pretty problematic. Also, beware reply all. And I think this is just good common sense life advice. Be really careful before you hit that reply all button anytime, but especially as a council member. Always think twice before you click. But exchanging an email can constitute a meeting if it is involving a quorum of members, and then you start talking shop. And the place where this gets the hardest is usually when constituents are emailing in to council and stating something really important that council members, of course, want to respond to, right? So I think one of the ways that we can run into issues with that is that people will, out of the goodness of their heart, want to reply all so that they can get to the bottom of what's going on, rather than asking, oh, Madam Clerk or Mr. Mayor, could you please, have the appropriate staff member look into this issue and make sure that they give us a briefing on what's happening, or individually reaching out to that constituent. If you do individually reach out to that constituent, that's perfectly fine. It's just that reply all that can kind of get people going sideways. However, simply receiving information without comment, that's not considered a meeting. So don't worry if a constituent does, email all of you all at once and gives you a piece of information. So long as you're passively receiving that information and not actively engaging in that conversation, you're likely going to be on the right side of the OPMA. So, pop quiz. Does it violate the OPMA for a quorum of the city council to communicate to each other in advance of a public meeting how they intend to vote on a piece of proposed legislation? So this is what's called quorum seeking. So this can be a problem because essentially this is evidence of a potential serial meeting. And there can be an inference that this has occurred depending upon what the scenario involves. So if you're actively committing or promising to each other to vote as a group in favor of or in opposition to a piece of pending legislation at a future public meeting. So it doesn't matter if it's actually at the public meeting. You guys can talk about it all day long. It doesn't matter. But this is when it's outside of a public meeting. But that commitment can be an evidence that a majority of the body attended a separate meeting with the collective intent to take an action in violation of the OPMA. So that can be a little uncomfortable. And since that is a bit of a gray area and a bit wishy-washy, it's always better to err on the side of caution. And, if you're feeling like it's getting too close to the line, it might be. So just be a little careful. So some quick reminders on this. Again, passive receipt of information is perfectly fine. Discussion of issues can be an issue. Unless it's for informational purposes only, don't send an email to the entire council. Or if you do, put everybody on the BCC line so they can't reply all to each other. I do that all the time when I send messages to council. Oh, goodness, I scrolled my mouse. I am so sorry. I didn't mean to make you dizzy there. If a majority of members are taking an action through a series of phone calls or voicemail, that would constitute a meeting and could be a violation of the OPMA. And then also, this is really important too. Let staff know if you are attending a function, a community event, or something along those lines, as in your role as a council member, let staff know so that they can all properly prepare for a potential quorum and potentially put out a notice of potential quorum for a particular event. So I'm thinking like, I don't know, July 4th picnic or, something like that, some community sponsored event. Those are the instances, or even a Chamber of Commerce meeting. The penalties for OPMA violations can be pretty steep, usually, and they're to an individual. They're not necessarily to a city. So that's a distinction between the Public Records Act and the Open Public Meetings Act. Because this is going directly to the actions of the individuals that were participating in it. So it's not necessarily something that the city should be responsible for. So be mindful, the first violation, and it's usually dependent upon, who knowingly attends, right? You're knowingly engaging in this wrongful activity. So you get escalating penalties as it relates to that. The other issue is that, of course, any action you did take at that illegal meeting is not going to be enforceable. It will be null and void. So with that, I will stop. I will say social media is considered a public record. Your engagement on social media you can be creating public records in that instance. So just be mindful about that in the way that you're potentially talking with constituents, the way you're communicating with them. I highly recommend funneling everything to your city email account. It's just so much easier to keep track of that in that way. But just be mindful that, if you're doing things in your capacity as a council member and not as a private individual, then those things are likely going to be considered public records. So just, err on the side of caution. And again, if you have any questions about any of this, or if you're like, what about this? What about that? You want to talk through hypotheticals? I'm happy to do that, of course, through the proper channels. And I really appreciate you suffering through that quick, very fast crash course on open government.
Does anybody have any questions for Joanna while we still got her?
Yep. So I am assuming that the attorneys serve as our parliamentarians at these meetings, correct?
That's correct. We do.
Then who serves when you're not present as our parliamentarians? So if we have those questions, who do we direct them to?
So in those instances, if we are not present, that would have to be discussed amongst the council and the presiding officer in making a determination in that regard. Or if there was a serious concern about that, whether or not it was being done appropriately as far as parliamentary procedures are concerned, you can always follow up with this too. I mean, there's a lot of different ways in which we can address those issues, and it doesn't always necessarily mean an immediate ruling at that particular moment. But if the council wanted to have us potentially on call or something like that, rather than just being in full attendance, that might be something we can talk about.
Thank you.
Go.
Yeah.
At the beginning of the meeting or this training, you talked about decorum, and you talked about everyone needs to be heard. However, on the parliamentary rules, if a motion is made and seconded, somebody can call the motion and effectively stop discussion. Yep. How do you balance that?
So that still requires a vote. So right. If you guys want to keep talking, then vote it down. Vote down that motion to call the question. But again, this is going to be a situation of majority rules. There is also an instance where you also need to balance the need for having an effective and efficient meeting as well to be able to conduct the city's business. So there's that balancing act between making sure everyone is heard and also moving things along. Parliamentary rules also require that each person have an opportunity to speak before somebody who's already spoken can weigh in again. I know sometimes that doesn't always happen with organic conversation, but technically that's the way things are going. But if you're concerned about not wanting to end debate on something, then folks would just vote down that call to question motion.
Yeah, but a majority of the council can shut down one other member just by doing that, calling the motion.
That's true. That is true. But there's also other outlets for that individual council member to use to voice their opinion as well. So it's not, it is, again, it's that balancing act. And yes, it is kind of a majority rule situation and that can occur. But I think more of decorum is more of like, let's not shout each other down. Let's be respectful. Let's allow people the opportunity to be heard. And hopefully, if the council is engaging in things in that manner and a person has a need to express particular views, then that can proceed in a civil way. Call the question motions aren't that common in my experience. I haven't had a lot of people use those, but if we do get in a situation like that, that's something that we can certainly deal with.
I have another one. We just got an invitation to a groundbreaking, and it's potentially a quorum will be there, but we don't intend to discuss any city business. Do we need to advise people that it's a possible quorum at this groundbreaking, or how does that work?
I generally recommend that you do, just to say notice of potential quorum. That is something that other cities will regularly engage in when they have such groundbreaking events like that. So the reason for doing that is to, just in case people start talking about business, agency business, then the public has received notice that there is a potential quorum that may be at this event, but that there's no action anticipated by the council at that. I have some examples too. I'm happy to share those.
What'd you say? Oh, okay, I'm done.
Yes, Chris.
So my question revolves around attorney-client privilege. And is there a difference between rules for municipal boards versus private boards as far as attorney-client privilege? Are they the same across the board in their application?
I think it's a little bit different when it comes to private boards than it is for public government, right? And it's more of a public records question than it is an attorney-client privilege question. I think one thing to always bear in mind, though, with any of these things is that anything discussed in an executive session must be held confidential, and that is required underneath the Open Public Meetings Act. And also, if you do disclose that information, then you are waiving that attorney-client privilege. So that's a really important thing. So that's going to apply to you, whether it's in a public setting or a private setting. But as far as like the nuances, I think it's the attorney-client privilege doesn't cover as much as you think it does when you're talking about in a public setting. So
I guess to explain my question deeper is when you do look at the allowed and explained RCW as it comes to Open Meetings Act and executive meetings. That to me, where attorney-client privilege fits into that is very gray. And that's why I asked that question, where that, it seems to me if you look at the list that somebody exercised attorney-client privilege not on that list and then was sued for it, won the suit, and now it's part of the list. So is that consistent with how that works? Or,
I see
and that's why I asked the question about attorney-client, because it's vague, and where that line gets drawn is challenging.
So remember that the executive session exemption, the confidentiality of executive session is actually not attorney-client privilege, though both the executive session confidentiality requirement and attorney-client privilege can apply. But you don't necessarily have to have an attorney present for every instance of an executive session if you look down that list on the RCW, but you do have to have them present for particular discussions that do occur. So like potential litigation and things of that nature. So that's kind of the Venn diagram in which they overlap, right? So there's the executive session confidentiality, attorney-client privilege, and sometimes they meet.
So if you think you're going to have something that will go into attorney-client, and you're concerned it might not also meet the bar of an executive session, how do you manage that? Or how should we manage that?
Well, I would invite you to consider reaching out to us through the normal channels. I think usually that would be via the mayor's office, discussing that with the mayor, asking the mayor for, and actually I'm trying to remember what Othello's particular requirements are, but that's something that you can talk with legal counsel individually about as well. It doesn't necessarily need to happen in a meeting, especially if it is one particular council member that has a question. And then if it is something that the entire council needs to be brought into, and if it does fit within that framework of executive session, then that is something we could discuss. And if it is not something that fits within those executive session exemptions to the OPMA, then that would be something that potentially legal advice via a confidential attorney-client privilege memo with legal advice would be able to cover.
Thank you, I appreciate that. It's probably launched a major debate for me to have in the near future, unfortunately.
That's okay.
Okay, is there any further questions?
I have more.
Okay,
The need to put something on the agenda to discuss it versus having new business where a council member can just randomly bring up something that wasn't on the agenda and kind of surprise the public that this subject came up.
Oh,
balance
so you're
there.
talking about the concern, like how do you balance that with the OPMA, like the ability for council to be able to amend the agenda?
Well, the bottom of our agenda says new business. I could bring up anything and
Mhm.
shock and surprise my council members and the public. And
Yeah. Well, because you've given notice that a meeting is going to occur, the public has the option and opportunity to attend, right? So that meeting is going to be open. That's really the kicker. The council can amend the agenda at any time. That's not necessarily, it can be controlled by council rules, of course, but underneath the OPMA, there's no restriction upon when the council can amend an agenda to add an item. That is something that could occur. You could bring something up, but again, any action taken on that would have to have a majority vote by council. And the repercussions for that may not be legal in nature, but they could actually be issues of trust within the community. So not everything's a legal question. Sometimes it's a, could you do it or should you do it, right?
right. But I could bring up something in new business, and we could take what wasn't previously on the agenda at the end of a meeting and take a vote on that.
Yeah, you could make a motion for that. That could be something that could occur if it is within council rules to do so. So there might be specific times in which the agenda could be modified, and usually most council rules that I see do allow for some exceptions and flexibility in that. But again, just because you make a motion doesn't mean it's going to be seconded, and it also doesn't mean that the entire council is going to vote yes. So you could make a motion and people could just say, no, we're not going to talk about that and move on. So.
I got one more.
Yes,
I'm
go
a
ahead.
I'm a curious guy, so
That's okay.
I wasn't sure on social media. If I go on my private Facebook page and say I'm going to go to council and I'm going to take this action, or I badmouth council or whatever, is that part of the Public Records Act? My private
It
Facebook
could be.
account?
It could be. Yeah, it could be. It really depends upon what the content of that post entails, and whether it's intended to be a public statement. So if you're saying, I'm going to take this to council and ask for this action, I think you're absolutely making that statement in your capacity as a council member. But there can be some gray areas with these things too. So yes, it can be considered a public record for that particular post. The reason why folks can get kind of upset about this is that it's not necessarily that your entire Facebook account is going to be, subject to public disclosure for a public records request. It will be for a specifically identified record, right? They'll say, I want this particular one, but they're not going to be entitled to your private messages to your wife or something like that, right? But there is, the issue of potentially if there were a lawsuit down the line, then your entire Facebook account could be subject to discovery, and it could be subject to an in-camera review by a court. So that's part of the reason why we kind of try to discourage that. But really, it's up to you. Whatever level of openness you are comfortable with, I just really recommend caution and thinking carefully about some of this. And it's so hard to do, especially in the society of the day and age we're at, right? Where we've got that instantaneous post, right? And that feedback that we're getting and the communication, the connectivity. It's really a positive thing, but it can be a little dangerous too, right? But that's not to say that, if you get a public records request for those things, it's not an insurmountable thing. It's actually pretty easy to respond to. It's just making sure that we do respond to them.
Does the city have to answer to that? Can somebody request, tell me what Mark said about city council on March 1st, and the city has to research that?
The city would be requesting that you gather those records and provide that to them so that they could compile it for that public records request. And that is something that's very common. Staff has to compile those records. Of course, you could ask for assistance with that. It depends upon kind of how the procedures operate within the city, whether you have the resources and capacity for that. But I have had instances where a public records officer will assist a council member in looking for particular records and transferring them over as well. But, those are, again, these are all things that we've run into before, and they're all things that, you know, you can work through. And it sounds scary, but it's not as bad as it sounds. I will say this too, because this is really important. Complaining about your boss at work, like, is not the same thing as creating a public record. So, so if you're like, so say for instance, I am, you know, working for a particular city, and I work in the public works department, and I start to complain about, gosh, my boss is such a jerk. I really don't like working for this guy. He's the worst. That's not a public record because it's not relating to agency business. And I'm not doing that in furtherance of my agency business and my job, right? It's just me grousing about my boss. But if I then pivot into saying something else that is not personal, and is relative to my job and is a function of my agency work, then that could be disclosable, that whole record. And it's going to be awfully hard to make an argument that, oh, this portion of that record's a personal record, but this is a public, you know, professional record. It's a little kind of blurry. So.
Thank you. I'm done.
Okay. So be very careful with your personal cell phone devices, especially texting. They can be
Yes.
subject to information asking for stuff on them. Is there any more further questions? Jake, this time is normally reserved for the council meetings, but this is a very important subject, not only for us, but for our audience. I will entertain a question, but I won't entertain a comment. Okay.
I want to appreciate the presentation that she's presenting, but I think the one key thing she's missing from the Open Public Records Act, and correct me if I'm wrong, that no citizen can request public records of their voting status, what candidate they vote for. I think that's excluded from the Public Records Act, correct?
There's a lot of things that are excluded from disclosure under the Public Records Act as it relates to voter information. But because the city doesn't regularly engage in those things, and it would be more of a county question because elections are generally handled by the counties, the city is not likely to have records of that nature. So, and I try to like tailor my advice for the city in particular. So.
All right, thank you. That's all. Thank you.
Yep.
Appreciate it.
Thank you very much. Now, I know open public meetings and public records is a state requirement, the training, every 4 years, and for newly elected officials. Will this satisfy those needs of that training for everybody?
I think it does. Yes. So if you'd like, we can create a record of that for you all, and supply that to you. That would be perfectly fine. But if you've also satisfied it in another way, that is fine as well. But yeah, I'll work with Tanya about that.
Okay. Yes, send it to Tanya and she will take care of it and we'll have those on record.
Sounds great.
Thank you.
Thank you very much.
Okay, now we will go on to finished business. Do we have any unfinished business? Okay, we'll go on to new business. Do we have any more new business? Yes, Kelly, I know you had some things you wanted to bring up for new business.
Yes, I do. Thank you so much. I hope you can hear me okay. I had a meeting on the 5th with the Sandhill Crane Festival Committee, and they had several actionable items that they requested that we bring back to the council to discuss. The Sandhill Crane Festival is March 20th to 22nd. They will be doing door bags for 400, the first 400 attendees. They did ask if the city would have anything that they would like to contribute to put into those door bags. Some businesses are doing things like pencils or stickers or a brochure, those types of things. That was the first request. The second request is that they are doing a city cleanup day on March 7, where they are, as a committee, going to the different areas in particular that they will be using for the festival to clean things up. They are wanting to know if they could partner some with the city and try and coordinate our spring cleanup day that we typically do, I believe, in April, to be closer to or on March 7th. They were, I guess, typically, historically, they've been able to use our dumpsters as well. So there was some question and wanting to double check and make sure that that would be something they could do again. And asked if there could even maybe be a message that goes out in the utility envelopes to people to just let them know about the festival coming and the cleanup day to try and have people be aware of kind of keeping their own personal yards and areas a little bit tidier because we will have a lot of visitors in town that weekend. And the final ask was about potentially the city doing a banner that would go across Main Street, just saying, welcome to the Sandhill Crane Festival for that weekend. So those were the three actionable things that they requested input and potentially partnering with the city.
Okay. So on the cleanup days, what have we did on the past? I know the spring cleanup has always been in April, but is there any way we could work this in conjunction? I don't know if it could be done this year or not that early. That's only a couple weeks away.
Yeah, it's possible that we already had an announcement go out with our utility bills.
Yeah.
But we can look in the morning. We can double check. And if there's a way we can do that together, then that's great.
Okay.
Mayor Johnson?
Yes.
I don't think we have any more banner locations to hang a banner across the streets anymore. I think all those locations have been removed, as I remember. Mark, do you remember any of them? I mean, you had the one right there by the bowling alley, and that one failed. So the only active banner that I know of is the one that's at the city sign. Unless somebody knows of any other. I think all of them have been removed.
I'm not sure.
That's something that I think we're going to have to check with Public Works to find out if it's even.
Yeah, and we could possibly put that where we put the Christmas garlands also,
There you go.
Yes.
maybe. But we can check with Public Works, yeah.
Okay.
They want to fly over Main Street?
That's what it sounded like.
Yes,
Yeah,
the request that it would span across the street. Yeah. Yes. And that may not be is even a possibility. I didn't have that information. I just let them know I was counsel.
Okay. Yeah, we got a pretty wide Main Street, and that'd be quite
What's
a bit.
the height?
Yeah.
Yes.
It's when a truck catches a hold of one, it's when you really get a little rodeo out of it.
Okay, we'll check into that a little bit further to see if those are possibilities for that. Is there any more new business to be brought up tonight? Okay, with that, also the council will receive the building and planning report, Public Works and Engineering report, and the police department report. If there's no further business, this meeting is adjourned.
Yeah, they used to have that one right outside my door.